invitation to this seminar. I have to say I enjoyed participating in this seminar in the past, and so I'm very thankful that I can also present some ideas today myself. Based on the last event with Eloise and Aurélie, and also some discussions with Alessia, I'm happy to maybe, let's say, to take the next step and to some extent continue where we ended last time. So just as a brief remark, what I'm presenting today is part of these Chaumonnais activities, where at the beginning I was focusing more on the relationship of EU law and ethics, and now it's more the focus on values. If you're interested in any of those activities, you can see it here on the right-hand side where to find further information. Now, starting from a law perspective, I have identified in the past, so especially in this green book here on the left-hand side, several examples where the law of the European Union refers to non-legal concepts, basically ethics, also morality. And once those concepts are then reintegrated into law and also have certain legal consequences, I was curious if the concepts to which EU law refers are substantially defined, so that we have enough legal certainty, knowing that legal certainty is linked to the rule of law, also one of the values of the European Union. And so what I've argued in this book was basically that if there are any uncertainties that remain, that reference should be made to the values of the European Union and to human rights. Hence also now this new focus of the new Chaumonnais chair. Talking about this, those references to the non-legal field. So we are here in the field of practical philosophy, where we're basically dealing with three normative series: so deontology, consequentialism, and virtue ethics. Talking about values and human rights, I think it's important to clarify that EU integration process has started as an integration process in an economic field. The objective, if you like, was to safeguard peace. So the plan of Chaumonnais, presented by Robert Schuman, and only later on we had human rights. So first in the case law of the Court of Justice, later in the Charter. Then we had also this political integration, and only, if you like, in this simplified way of clustering, only at the end, so with the Lisbon Treaty, the EU has also turned into a community or union of values. So as I said, since the Lisbon Treaty, we have those values of the European Union, which we can find in Article 2. And as you can see here, the first sentence differs from the second one. First, because the first sentence is addressed to the Union. The second one refers to the member states. And it's interesting to note that the wording "is founded on" implies that those values are already pre-existing, which could then also imply that it would be difficult to amend them, because it's like they are already pre-existing to the Lisbon Treaty. So we have human dignity, freedom, also rights of minorities. And then, as I just mentioned, the second sentence refers to the member state level, or more precisely, a society. And that's also interesting to note, because it's not in plural, but in singular. So one society in the current 27 member states, where we have pluralism, non-discrimination, tolerance, and so on. I will talk about solidarity later on. We have also gender equality, which supplements equality mentioned in the first sentence. I just want to highlight some of those values. So as you can see, human rights, what I've identified as one step in the historic development of the European Union. So human rights are also part of the first sentence. And again, we can find that in the Charter of Fundamental Rights, basically. And just as one example, non-discrimination, that's a one value, which can also be qualified as a principle. And I will refer to that later on, where you can see, based on this Commission document, that we have several EU directives which do prohibit non-discrimination in various fields. So that's the vertical axis, based on various grounds. So that's the horizontal axis. There are some additional documents, and yeah, I will not go too much into details on this. As you might know, again, in a simplified way, there are three ways of how the law of the European Union can have an impact. So maybe to start at the bottom, so harmonization of national law, especially via EU directives. We've seen the anti-discrimination directives. You all know the cross-border healthcare directive. Second, and that's how the Court of Justice has paved the way in this field of patient mobility. So those economic fundamental freedoms, for instance, the freedom also to receive services, and of course also human rights, where we have, for instance, Article 35 of the Charter on healthcare. As it's mentioned here, human rights are not static concepts. I think that's very important to discuss. And it's a book written in German by Ferdinand von Schirach, but maybe some of you know it, where he suggests 5 additional substantive charter articles and 1 procedural. And of course, that can be a more general discussion whether human rights or human rights document should be short and precise, not reflecting current challenges, because they can then be solved via case law, or whether those, or whether there, for instance, is a necessity to have also now a specific human right in the field of artificial intelligence, for instance. As we also discussed it last time, in a case which you will also see later on, the Court of Justice, to my knowledge, and I discussed it with the judge and he confirmed it, for the first time referred to this concept that we know from the Strasbourg Court, so this living instrument character, so which means we have not static but concepts that that develop. As you can see, with the result, quote, that regard must be had to changes in values and ideas, both in terms of society and legislation. And if we go to the national level, here, the German Constitutional Court, one idea which I think very much fits into this context was the German Constitutional Court in this case concerning climate change, also referring to the rights of future generations. I think which we now deem necessary in society, but also interesting to note that we can also find it here in the case law of one constitutional court. I already referred to values and principles, and now in terms of terminology, to distinguish those two concepts, there's some quotations which I brought along and which I translated as they were in German. So German scholar Di Fabio, he refers to values as the basic attitudes of people who stand out to their special firmness, conviction, correctness, and emotional foundation. And the idea is, though, that if you go beyond those values, then you're leaving the secure consensus of a society. To contrast values from principles, so values are, of course, very abstract, and maybe you can see that in a similar way as I just mentioned, that human rights might be maybe need to be more general or more abstract so that they can be applied to different challenges on a timeline, so to say. But here values are more abstract. So just to name human dignity as one famous example, and you cannot take human dignity in general and go to court. So there are some exceptions, but so values are more abstract. On the other hand, principles are more concrete. They have legal consequences, legal addressees. So if, for instance, a member state breaches proportionality as one principle, or also non-discrimination that I've mentioned before, obviously, then there you can have legal consequences. So that I think already explained principles and values. Now, if we move on from those general values to health values and principles, we can take away from this document of the Council from 2006, where basically the health ministers at the time, when we had the debate about the Services Directive, which was very controversial and which was also called the Frankenstein Directive, referring to Fritz Bolkenstein. So the health ministers tried to also give their input in this whole debate, which up until then was very much driven, or only driven, by the Court of Justice. And so they tried to define those health values, and not only values, and basically to give the credits, it's this document where I have taken this idea of more abstract values and more concrete principles. So here, as you can see, we have specific values, so universality, access to good quality care, and equity. And as you can see, equity is half divided because it's not the same as equality, but kind of similar. So therefore, I have classified it as half a specific value and half as a general value if we link it to equality. And obviously solidarity can be found as one of the common values, but also as health specific values. Underneath those values, we have operating principles. As you can see, quality, safety, care that is based on evidence and ethics, patient involvement, and so on and so forth. And now if you look into, or if we look into those first values, and then on the next slide, principles, you can see that here we get further clarification on those values and principles on the next slide. And I found it interesting. So the first bullet point here, that the health ministers at the time stated that these values and principles become a reality in the health systems of the EU, and that we have significant variation between member states. So it reminded me of the EU's motto, United in Diversity. So as you know, we have Bismarck and Beveridge systems and also other differences. So some common ground, but still some diversity. So if we go through those values, so universality, access to care, equity, if you read through that, reminds me personally more of non-discrimination than equity in the sense of equality and the challenge of having more general laws, and then the necessity to find a good solution in a particular situation, and obviously also solidarity. We also have, as is mentioned here, beneath these values, those operating principles. You can read through the text, but I think there is no need to explain it in detail. Now, inspired by these values and principles approach from this document, those council conclusions of 2006, I have basically summarized or sketched this overview. And to briefly explain it, if we start at the bottom of the slide, obviously the law, for instance, because that was in the field of digitalization. EU law, or law as such, here the GDPR. Of course, the law is always a minimum standard, which is not negotiable. But beyond that, and especially if we have a soft law document like those council conclusions, so more a political document, we could or should strive to have a more ambitious approach by referring to those values and principles. And as you can see here on the left-hand side, common values, so not specific to one field. And then on the right-hand side, so highlighted in blue, basically the summary of what we've just seen on the previous two slides, so the health values and the health principles. Of course, if you take the book of Beecham and Childress, those 4 bioethical principles, you could say they are also specific to one field, but still they have also been applied to other fields, for instance, to digitalization by Floridi and others. So that's why I have placed them here in the general field, and then also some legal principles. And that's just an excerpt, if you like, which I discussed in 2 papers for certain challenges in the field of digitalization. Moving from the bottom to the top of the slide, and I think that's true both for the EU law as such, but also for this field of digitalization, but also for healthcare. This, let's say, more ambitious approach, having law as the minimum standard and then principles and values. So whilst some have referred to trust as a value, I would rather see it as an overreaching goal. So if a society, a legislator, whatever, complies with this approach, then the ideally would be that this enhances trust in this field. Now, to give you just one, or to focus on one value, one principle, solidarity, and as I just mentioned, those qualifications are not mutually exclusive. So solidarity, yes, is a value. It's also referred to in the EU treaties as a principle. And also the Court of Justice, when referring to solidarity, basically refers to it as a principle. So in energy solidarity, in migration, and in other examples, not as a value. Again, I assume, based on what I've mentioned before, that principles are more detailed, they have legal or can have legal consequences, legal addressees. So that's why the court seems to have a preference to refer to the principle of solidarity, not to the value. And that's why I have often referred to as the term of concept, which is should be seen as to encompass both values and principles. So talking about values, so Barbara Breinsack and Alina Büchs, they have referred to solidarity as an enacted commitment, to carry cost, to assist others if we have a certain similarity with those people. Annick de Ruyter referred to redistribution and risk pooling. And obviously, if these days we talk about solidarity, we can not only refer to social solidarity, as emphasized by the Strasbourg court in this mandatory vaccination case, but also global solidarity in terms of the COVAX initiative. If we move on from the law, hard and soft law, case law, to attitudes of Europeans, I always find it interesting to have a look into those Eurobarometer surveys, where we have here 2 slides. The first one, personal values of Europeans. Second one's values which Europeans think that they are represented by the European Union. So you can see some differences. So respect for human life seems, for instance, seems to be more a personal value than a European value, but overall there are a lot of similarities. As you can see here, where solidarity ranks in either case. And I think also interesting these days, as you can see, the blue line between respect for other cultures and religion. So respect for the planet, that was a new item which was first addressed in 2019. So bigger in terms of a personal value than as a value which represents the European Union. We already had that in the last seminar where we had the presentation of Eloise and Aurélie. Talking about the non-static element of the whole debate, since some years we have more and more cases in the field of EU law and religion. So here the slaughtering of animals, and you can see again moving from the bottom to the top of the slide the relevant EU law, and then those three cases from 18, 19, and the last one from 2020. And if we look into this case from the newest one from 2020, it was very interesting that in this case, again, to my best knowledge, for the first time, the European Court of Justice stated a value outside Article 2. So we can find the idea of animal welfare already in EU law, primary and secondary law, but so for the first time explicitly mentioned as a value, but not one which is listed in Article 2. It's also interesting to realize that, of course, that's the first value which does not entitle human beings, but animals. And if before I've referred to human rights, not to fundamental rights, that's basically because if you read through the Charter, most or almost all articles refer to human beings, not only to EU citizens. What was also interesting to take away from this course was that if there's a necessity to balance certain interests, that this would not take place at EU level, but that this task is referred to the national level. And finally, and that was already mentioned before, that the Charter has been referred to as a living instrument, so these changes in values and ideas have to be taken into account. It is remarkable, and Tridimas referred to that in his book about the general principles of EU law, that earlier on the court had declined the invitation to recognize animal welfare as a general principle of law, and now we have it, and we even have it as a value. So I think that's that underlines this qualification as a living instrument. I think it's also important to contrast it against the background of the One Health and also the planetary health approach. So here you have some quotations. So taking a more holistic view concerning humans, animals, and the environment, and especially with the origin of the coronavirus, I think that is quite obvious. If you look into council documents, we have this One Health approach, especially in the field of antimicrobial resistance. So here, quotation from 2012, and also planetary health, which takes a more holistic view. If we go back one step, then I think it's we can again see this step-by-step approach, which is very much characteristic of EU integration as such. As at the beginning, health was only a reason of justification in the Coal and Steel Community Treaty. We then had workplace health in the 1957 treaty, and then step by step we had more EU law in this field. So sometimes informal ideas, proposals, drafts, as the 1984 Spinelli draft, being more ambitious, and then reality lagged behind. So we had some approaches before the Maastricht Treaty, then the Maastricht Treaty, which made public health a sectoral policy. Then we had this Armand draft for constitution of the EU, which also already referred to values, for example, also solidarity, as you can see here. Then the Amsterdam Treaty, Nice Treaty, and finally the Lisbon Treaty. So again, this evolutive or step-by-step approach. So to summarize, and at this stage, I have to thank Eloise and also Aurélie for helping me to get access to some of those documents. So if I just mentioned that EU law in the field of public health has very much evolved step by step, then we should also remind ourselves that in 1952, French Health Minister Paul Ribéry had an idea for European Health Community. So nowadays we discuss European Health Union. So where we have this European Health Union Manifesto, where Annick de Ruyter and others, some of the founding mothers of this very important initiative. And so today we because of the pandemic, we discussed some of those topics, and we should keep in mind that that was already an issue in 1952, so 1 year after the Coal and Steel Community Treaty. Again, this combination of more abstract values and legal or ethical principles, not mutually exclusive, and principles obviously can stem from the philosophical field and or from the legal one. This evolutionary approach is not only true for human rights, but also for values. And I've already referred to this approach of the living instrument, the inspiration from Strasbourg, which in December 2020 was also adopted, if you like, by the Luxembourg Court. Again, solidarity, which is a value and a principle, reveals this manifold dimension that values can have. We can also add general principles of EU law that I've mentioned, referring to the book of Tridimas, which are qualified as primary law. So it's even, we have already 3 qualifications. That's why I very often referred to those words as concepts, so to respect the fact that there can be manifold qualifications. And finally, and that was the discussion that we had last time at the presentation of Eloise, Aurélie, also together with Alessia. So now we have animal welfare as a new value. And I argued that therefore we can also take health, so meaning human health, as a value, especially if we take the more holistic approach of this One Health or planetary health initiatives or approaches, keeping in mind this close relationship of the environment, animals, and human beings. So, thank you very much for your attention, and I'm looking forward to your questions.
Okay, thank you very much, Markus. I'm just going to stop the recording now.